So now the recording is beginning. And my name is Mr. Max Chaudhary of Chaudhary Law Office. I'm an immigration lawyer who's been in the practice of Canadian immigration law for about 30 years or so. Excuse me. And this webinar is an opportunity for people to present their questions and receive not necessarily advice, but more precisely general guidance, which might give them a step in the right direction, maybe give them the impetus to perhaps pursue their immigration matter further after getting this initial sort of support for scrutiny about the merits of a possible immigration course of action. And this is being recorded, and from time to time, people will come and go during the course of this webinar, usually arriving for the purpose of answering their question and perhaps maybe then getting off the recorded Google Meet venue, having received an answer to their question. General guidance is the end result, is what I want to emphasize. As I indicated, this is being recorded, so if you pose a question, then please make sure it's confidential, because elements of this webinar will be put into little pieces and will go on social media. So in order to maintain rather confidentiality, it's important that if you do pose a question, then exclude anything personal, like names and file numbers, for example. With that in mind, the way to approach this for anybody who's asking a question is to simply pose a question in the chat, and then based on that question, I'll review it and then give a response. In some cases, more detail might be needed, and if that's the situation, I will express that to the person posing the question in the chat. And I just want to know whoever's on the line. It looks like one individual is here. So if they could just send a message in the chat letting me know that they can hear me, and then I'll be in a position to continue. So I'll just pause for that, because there is one person here for the purpose of receiving a question. So just to bump this up, just pose that specific question that I just had to whoever's on the line at the moment. And then, with that in mind, I will await the question from whoever is currently on this Google Meet venue, and then endeavor to answer it. Just 1 second. So I will wait for a question at the moment, and then I will keep it paused for now until I receive a question in the chat. All right, I received a question from a different venue or channel, and they said they would indicate this ahead of time. I'm just retrieving that question. So the person's indicated that they have been instructed to report to the Canada Border Service Agency. In this case, it's the main office at 6900. And he was advised when he went to the CBSA for him and his wife to apply for an Indian visa for their Canadian-born daughter for the purpose of facilitating the entire family's removal from Canada, given the fact that their humanitarian case was rejected. And in accordance with that, the individual did visit the Indian consulate. And during the visit, the consulate requested passports for the parents of the Canadian-born child, along with a copy of the marriage certificate in order to proceed with the visa application for their daughter. So in other words, one impediment to removal is sometimes the need for the CBSA, or the Canada Border Service Agency, to make sure that there is a passport or a travel document in this case, so that the foreign nationals from India who are removal ready can take their underage daughter, who is Canadian, to return to India to facilitate the deportation of the family and not separate the daughter from the parents. However, in these kinds of circumstances, the sort of gatekeeper for this purpose is the consulate associated with your country of citizenship, in this case, India. So the person indicated that those documents are actually not in their hand. They're actually with the CBSA, the Canada Border Service Agency. So this is a common scenario. For example, with refugee claimants, your passport is seized at the outset when you initiate, for example, a refugee claim, and on occasion it's misplaced. But the net effect of this is that the individual can't be removed at the moment. And what would likely happen is, when the individual does return to the Canada Border Service Agency and explain that they cannot get a travel document for their daughter because they don't have the passports, they are in fact with the CBSA, then the CBSA would have an impediment preventing the family from being removed, because it's inappropriate to remove a set of parents or a parent and separate them from their Canadian-born child. So effectively, this combination of the child being Canadian, hence needing a visitor visa to India, to return to India, constitutes an impediment which effectively buys time for this couple to see if there's any other way to deal with their situation, such as taking their refused humanitarian and compassionate case to the federal court. In the event that they recently received the federal court, rather the H&C refusal, because you have to take those cases to the federal court within 15 days when it's an inside of Canada decision. And thereafter, the family could, if the CBSA does give them the passports, and then thereby presenting those to the Indian consulate, the CBSA might try to remove them again. But in a situation where there is an ongoing federal court case, then a stay of removal, which is a pause of removal, can be considered. The key to a stay of removal is that there has to be an ongoing federal court dispute between the parties. The potential one that would work in this case would be filing a judicial review application against the negative H&C application, leading to a dispute between the family and the CBSA, or the Canada Border Service Agency. And then what happens is, when there is an ongoing federal court case, and in the event there is a what's called direction to report for removal, then the couple can make a motion to the federal court saying that there would be irreparable harm to them, and there is a serious issue, namely the refused H and C case, which, for example, if there is a mistake, then the argument would be that there is a mistake and that the H and C would have been successful. And then a federal court judge has to evaluate in a very quick fashion before the removal whether or not there is a serious issue in this case. Is there an error in the humanitarian compassionate case that could be challenged at the federal court? And a judge could pause the removal after the couple receives the direction to report for removal on the basis that there is a serious issue and that there may be a chance of success to challenge the refused humanitarian compassionate case. And also, if the judge makes a finding that there would be irreparable harm, such as harm that cannot be compensated by money, such as a life or death issue, perhaps if there's an illness that can't be treated there but can be treated in Canada, or if there's a potential loss of rights affecting any one of them, the couple or their Canadian-born child, that irreparable harm in combination with the serious issue could lead a federal court judge to pause the removal pending what happens to the court case that was filed at the federal court. So that's a potential course of action that could take place in the event that the CBSA is requesting you to report, to take steps to facilitate your removal, such as going to get a passport from the relevant country from whence you hail from. So with that in mind, I'll see if there's any questions either that were emailed ahead of time or in the chat. I don't see any in the chat. If there's anybody else on the line, please feel free to make a question, to pose a question in the chat, and I will endeavor to answer it. Excuse me. I will look and see. There's a list of questions that were given to me last week by people who reached out, and they said they would catch this on when it is uploaded. So for this, yes, okay, so I do see another question posed previously, which is that I was, this is the person indicating their background and their context, where they say, I approached the Canadian border from the United States at I believe it was the Thousand Islands crossing. And I had a temporary resident visa, visitor visa, which is the counterfoil, the sticker in the passport, which allows you to enter Canada. And they indicated that the officer posed some questions about the origin of their money, the money being relevant because previously, before they exited Canada, they filed for what's called a visitor record to maintain status. The whole point of that was that they wanted to extend their work permit. However, the work permit, in this case, it looks like it was a PGWP. It was expiring, but they were able to get a labor market impact assessment. And that LMIA has not yet been disposed of. So there is no decision on the LMIA. And if you Google around, you'll know that most of the time, not always, but at least in the circumstances of this individual, an LMIA is required in order to extend their work permit beyond the normal, typically 3 years duration of the PGWP. This individual left Canada for whatever reason, I'm not sure. And then they wanted to return to Canada, but before they left, they did file to extend their status not as a worker because there was no LMIA, but rather as a visitor. So they filed a visitor record to extend their status in Canada. The officer indicated to them that they reviewed the documents in support of the visitor record, and they noticed there was a large transaction, and they were of the view that this money was not the money of the person who wanted to present this set of funds for the purpose of showing that if he is going to be a visitor, he does have sufficient funds to be in Canada without the need to work. This has led to, according to the individual, some concerns about whether he is a genuine visitor. So with respect to what is a genuine visitor, you have to have the essential hallmarks. Firstly, a temporary purpose and sufficient funds for your stay. And of course, the very subjective element that you will return after your temporary purpose associated with that visit to Canada has ceased. In this case, one key component, namely the amount of money for the visit, was deemed to be a bit questionable. And then they asked, what's going to happen? So in this situation, the CBSA, the Canada Border Service Agency officer at the port of entry, in this case, it's a land border between Canada and the United States, they have the option, if they want, to express in a sort of mild or gentle way, saying, I don't think you meet the requirements of a visitor because you don't have enough money. You can leave and try to re-enter Canada when you have better evidence. This could be a problem if the individual is coming from a faraway place, like in Asia, and then they'd have to simply get on a plane and then try again. The alternative would be that persons in this situation might be confronted by a CBSA officer who says, I don't think you meet the requirements for a visitor. I'm going to let you in. I'm going to impose terms and conditions that you report to the CBSA twice a month. And that term and condition would also include that when there is an admissibility hearing or minister's delegate review, you show up to that and we discuss the merits of your visitor visa application. And in this case, the merits and the subject of that would be whether this person does have the evidence to show that he is a genuine visitor. And then the outcome of that would be that if the officer at the minister's delegate review or at the admissibility hearing through a manager determines that the person does not have sufficient funds, then they could issue an exclusion order for the person to leave Canada. An exclusion order means that there's a 1-year exclusion from Canada, so the person cannot come back to Canada. This could be worse, however, in the event that the officer makes a finding that there was a material misrepresentation during the course of presenting their application to enter Canada as a visitor. If that's the situation, then there could be a concern that this could lead to a 5-year ban because a material misrepresentation that is determined for the purpose of trying to facilitate some visa or privilege in Canada does lead to a 5-year exclusion from Canada. And based how the law is structured, 5 years being such a long time, with economic-based immigration depending on the age of the candidate, effectively a pathway for permanent residency would be closed off. And the person would have much more difficulty coming to Canada either as a visitor or through acquiring permanent residency. So those are the issues that do come up in those situations with this interaction at the port of entry. If anybody's joined us, please feel free to pose your question in the chat. In the alternative, I will go to questions that were emailed to me, because these will be posed and then responded to and then uploaded to the website, where the people who pose the question can find the response to that. Right? I'm just going to look for the next question here. And that relates to what is the pathway for somebody who is older than typically 35 years of age? Yeah, I think that is the age. And how much effort is involved for that? So, as you may know, if you have noticed, the express entry system is becoming more and more truncated in terms of the viable pathways for immigration. And this is owing to a number of factors. One is that the federal government is having the phenomenon of targeted draws, which are draws for people in the express entry pool whose experience aligns with the, I suppose, short and medium-term needs of Canada's labor market. So effectively, that means that individuals who, if I think about the recent draws, are in the healthcare professions, physician, maybe dental care worker, like hygienist or dental assistant, a very limited number of IT jobs, maybe only one or two now, as opposed to before. Things like cybersecurity, which is in demand. And similarly, healthcare professions such as related to personal support worker. Those are the ones that are getting selected for immigration under the auspices of the express entry inventory management system, the inventory being you, the candidate for immigration. With that in mind, the other factor is that the combination of points now is such that you need high English and you have to be under 35 and be subject to one of these targeted draws. This is exacerbated by the fact that the federal government has limited the amount of spots to the provinces, because the provinces have an allocation of immigrant spots, and that's based on the local needs of each individual province. And because of that, the limited amount of spots in the provinces, plus the very narrow scope for who can qualify now under express entry, this question is even more germane. This individual is over 35. So then what's left in this situation if you do not have skills in the healthcare sector or some of the other science, technology, or engineering jobs, or personal support worker? Then what's left? In some instances, there is a possibility that if you did have business experience, then there are some spots allocated primarily to the provinces for entrepreneur categories. Most provinces have these, except for, I believe, the province of Ontario, which has, for whatever reason, paused their entrepreneur program. And as a consequence, then one could possibly explore this, but typically when you look at the entrepreneur requirements for these individual provinces, you need a certain amount of net worth and a specific amount of money to invest. So for example, British Columbia, if you want to initiate or purchase a business, you have to put in $600,000 in a large urban center for that business in British Columbia. And if it's in a more rural area, then I believe it's $200,000 is the minimum amount you have to invest. But it's not a matter of merely showing the money. You, for the purpose of making a presentation, you have to typically show that you have a plan of business, either to purchase or establish a business in British Columbia. And they want to see certain key elements for them to be willing to accept you as a potential entrepreneur candidate, such as creation of a couple of jobs, maybe bringing certain technological advances to advance the training of Canadian workers, or some other benefit to the Canadian economy or labor market, such as exporting Canadian goods, things of that nature, which would be prized quite highly by the provincial authorities. And when you present that proposal, such as a business plan, typically most of these provinces also want a language test, but the good part is that the elements in terms of how high the language test has to be is pretty low. I believe it's like CLB4 for one of French or English, one of the official languages, as the threshold, because they understand that there could be business people who may not be fluent in English or French, but have enough basic information to set up a business. The other element to keep in mind is that, let's say you have a successful business that's required, because typically the minimum requirements is to show that you had 2 years of success, namely profit, in the past 5 years, either owning and managing the business, or maybe not owning, but being the senior manager of the business. So in other words, that's the same thing as saying they want to see a proven track record in business for the purpose of assessing whether they want to grant you a certificate to start the process of setting up your business in British Columbia, for example. Let's say you do. Let's say you do have the requisite experience and the requisite money, let's say $600,000 to purchase or invest a business. Then what happens? So in that circumstance, the provincial authorities would say, oh, we like your business plan. We like your language test. It's basic, but good enough. We like how you're going to create 2 jobs and or bring certain technology to Canada or export certain items from Canada. So they would issue a letter, and that letter would be for the purpose of facilitating your work permit. So you would present that letter to the federal authorities who issue the work permit, and then you would presumably get the work permit. And thereafter, the work permit becomes effective, and you're given usually between 20 and 36 months to operate the business. Keep in mind that in this scenario, you've already placed a business plan before the provincial immigration authorities. So periodically, they will, from time to time, check the status of your business. They will ask you to complete reports to see, for example, are the projections in terms of creation of jobs and or a certain amount of gross revenue, are they comporting with the business plan you proposed? And in that circumstance, assuming that during the periodic reporting about the business, that you do have a plan that is being executed properly, then at a certain point, 20 to 36 months thereafter, the authorities would say, yes, I think you've complied with this, and they would issue you another letter, and that would form the basis for you to apply for permanent residency in British Columbia through the PNP program as an entrepreneur. Keep in mind that in this scenario, when you're on the work permit, the expectation is you are the one managing the business. So writing the checks, supervising people, hiring, firing people. So the expectation is that you're going to be in Canada for the vast majority of the time. This individual said that they have a business already outside the country. This could be a problem in the event that they cannot delegate the management of that already existing business outside of Canada to somebody else, so that they can present themselves as being the decision maker and the manager for the Canadian business, which they're forming and operating for the purpose of getting Canadian immigration. So this is a sticking point for many people, because a lot of times they, if they don't have a trusted business partner to continue the pre-existing business, then they may presume this not to be worthwhile, because their whole basis for their success was that initial business. just on the same token, if there is a branch of a business that they want to form, they could consider what's called Intra-Company Transferee, and that's essentially a work permit that is used to say, at least in this scenario, that I want to form a branch of my already existing business in Canada, and I need a work permit because I shall be the senior manager for that business. And sometimes that works, although that it's not clear whether or not that can lead to a secure foundation for permanent residency, because as you may know, if you've watched the news, in March 2025, the immigration authorities removed the additional points for a job offer, which normally gave between 50 and 200 points, depending on, for example, if this was an executive position, then you get 200 extra points. So the whole idea about having an intra-company transferee and thereafter working in Canada and then being an employee of this branch, not the owner necessarily, and then getting extra points by virtue of being offered a job, that may not be a viable pathway now in terms of permanent residency, but it could nevertheless be the basis to get a work permit in Canada. And that would also obviate the need for an LMIA, this intra-company transferee type of work permit. So that gives a scope and a sense of some of the other pathways to obtain permanent residency without the typical express entry pathway. So with that in mind, I'll just take a peek to see if there's any other questions here. Just bear with me for a second here. Okay, I see somebody here online posing a question. So they're indicating that I'm on an LMIA work permit, which expired August 2024, with my family and 3 kids. The 3rd child was born in Canada, and I'm on an extension with implied status. What are the options for PR? Could this be the basis for humanitarian and compassionate application? So this is an increasingly common occurrence. People have entered Canada either as students and then got a 3-year work permit, or they got a work permit from the outset. And that work permit was supposed to become the foundation for permanent residency because of the points that you used to get, the aforementioned 50 points or 200 points. And this led to a proliferation of too many LMIAs, and this was exacerbated by the less than diligent scrutiny, apparently, that officers at ESDC or Service Canada were bringing to bear when assessing those LMIAs. So now, in this situation, with the points that you would normally get, not just the points for working in Canada under, let's say, Canada Experience class, but also the additional points associated with an ongoing job offer have now been eviscerated, and the person's probably no longer competitive given their age, which is 36 years old. So then the question is, what's been done? So there was a foundational pathway based on a work permit, which acquired Canadian work experience. It was supposed to get perhaps 50 or 200 points extra, but the point system abruptly changed, and they're no longer as competitive in the express entry pool. And of course, you may have noticed as well, the points are like 500 for the ordinary draws and 700 for the provincial nominee draws. So is a H&C, or humanitarian and compassionate application, viable? So in the ordinary course of events, being in Canada, and this is a very approximation in terms of what are the hallmarks of an H&C, but being in Canada for 2 or 3 years, it's not a terribly long time. So in and of itself, being in Canada for 2 or 3 years, having a track record of employment, that is not enough for an H&C, or humanitarian and compassionate, because the criterion is, at least one of them, based on an old case from 1970, is what would move a reasonable person to want to grant this kind of relief. So that's a very open-ended set of things to consider. But if we look at the pattern of what is a successful agency, oftentimes when there's a child, and the child might have not might, but is pretty clearly going to have a difficult time if they have to return to the home country, that could be the foundation for a successful humanitarian compassionate application. But from the officer's point of view, that doesn't mean that it's going to be a bit worse than Canada. It has to be something very specific. So examples I've encountered in the past are when there's a peculiar condition of the child, a medical condition or psychological condition. And sometimes when a child has these conditions, then the school in the country from where they came from, they just don't know how to deal with a child who, for example, may have epilepsy. And unlike here, where there are things like, I suppose, EpiPens and some rudimentary training and CPR that I suppose teachers have to have here, if there's a concern that the child simply doing their ordinary task of going to school in the home country, if that could be seriously jeopardizing their life, then it could be that that could form the basis of a humanitarian and compassionate application. Keep in mind that's not enough. There always has to be, especially if you're a working age, there has to be a firm track record of being employed. I mean, in this situation, I presume the person has worked because they were on a work permit, and it was on an LMIA-based work permit. So the person has a good track record of being employed in Canada. Hopefully the nature of the employment is one that's in high demand, so that there is some portability, so they could continue working for the next few decades of their working lives. And then if they do have a condition for the child, physical or psychological, that can't be worked out in the home country, then that could be the basis. It's similar with clients who they have a child who's autistic, and they're from China, and then the Chinese healthcare system doesn't really deal with these types of conditions very much. There's a bit of social stigma, and that could pretty objectively be proven that the child's formative years could be deleteriously affected because of things like stigma and the inability to get proper treatment for something like autism, particularly where the degree of autism is more than mild. So those are the peculiar circumstances that can make it worthwhile considering a humanitarian compassionate application. That's not to say that the best interest of the child is the only pathway. Sometimes, if there is a certain kind of medication the adult applicant has to take that's in short supply in the home country, plus they have some, assuming they're working age, they have some good track record of employment, then that's a potential life or death issue. So the other situation is that if there is, I think the person's added something. So health is fine with kids, but the financial situation is not good. So the immigration system is a bit harsh from time to time when there's a financial issue, because when you come on a work permit, the expectation is, by definition, it's a temporary application. So it's a temporary stay. In most cases, you can only stay for 5 or 7 years. And then you have to either transition to PR or leave and then come back. So in the situation like this, without something more, such as if there's not a health issue for anybody in the family, if there's the only other alternative would be if there's something more amplified in terms of danger or risk for returning to the home country. Like, for example, if you're a member of a minority that is not getting the appropriate protection from the police, they're getting some protection, but it's intermittent. And if there's some concrete evidence that people of a similar background in terms of minority status have also encountered something in the recent past, then that, combined with some financial establishment in Canada, could again be a basis for a humanitarian, compassionate application. This sort of straddles this issue of asylum, which is something with a lot more complexity, because then there has to be a categorical, well, at least on the balance of probabilities, there has to be a finding of fact that the police are unwilling or unable to protect you. So that sort of straddles a refugee type of scenario. Keep in mind that if you're in Canada, you could make a refugee claim, but it's by definition a bit odd if you've been in Canada and then all of a sudden you make a refugee claim, because why would you have fear of going back to your home country if you haven't even been in your home country for a year? That being said, it's possible there's a concept of refugee sur place, where on the ground, basically, where if, let's say, there's a sudden change in country conditions. For example, what comes to mind is Iranian nationals, where there was a huge crackdown, I believe 2 years ago, and Iranians who were here were allowed to extend their status in Canada to get a work permit. So that was something which led some Iranians to make a refugee claim, because maybe they were Christian or maybe they converted. So that combination of new facts that occurred while they were in Canada was still the basis for a viable refugee claim. Refugee sur place is the ideal, but that's a bit of an unusual situation for most people. Most people, they flee their country, and they may have to use a smuggler or something, and that's the nature of making a refugee claim. And then they come to, oftentimes, Canada, because it has a pretty robust refugee protection system, and they make the claim when they come to the country of Canada or shortly thereafter. So those are some of the scenarios that sort of cascade out of these changing country conditions, which might facilitate or be the impetus for making a refugee claim. So I think unless there's a follow-up, some context was given by the person who posed the question, which is that the education, presumably in the home country, is not as good, and it cannot be afforded financially because I believe the child is Canadian. And when you encounter a situation like this, it straddles sort of it takes some advocacy to make an agency like this work, because in this scenario, if I put the pieces of what has been posed all together, the person saying, well, one of the kids is Canadian. India does not allow dual citizenship. This is where they're from. And so that means the child does not have a right or an obligation. There's no obligation on the Indian government to school this child. This child is a foreign national, Canadian. And then what happens to the child? Then there's private school. Private school is very expensive. At least a decent private school may be very expensive. And if the child is now school age, like maybe age 4 or 5, then the question the parents have is, well, I'm in Canada. I cannot afford the schooling for one of my children. School is an essential component for every child. So what can I do? So in this case, there could be the rudiments, possibly, of a humanitarian compassionate application. That would have to be buttressed by cogent evidence showing that the cost of a school, private school per year, what is that? And compare that to what the skills of the person who might have to leave Canada for India are, and then based on those skills, what kind of salary or remuneration can they make? And then based on that conclusion, would it be extremely difficult to school the child in the private school system in India? If it could be made out that there's simply no reasonable way that the parents could afford the school, then you could fashion a best interest of the child argument. But you'd have to, of course, as I keep repeating, you'd have to have the basis for economic establishment like Canadian work experience, because that's a key indicator of whether you will be employed in the future in Canada. So with some caution, I would say it might be viable, but when I've encountered this, there was always an additional twist. Like, for example, I'm thinking of a case where the husband was from, I believe, Bangladesh, and the wife was from India. And there could have been the separation of the family. And it's sort of a universal rule. You don't want to separate you don't want to consensually separate a child from both parents. Aside from divorce, where there's the best interest of a child is evaluated. So that extra twist of the family perhaps being completely disintegrated, with the father destined to Bangladesh and the mother to India, and then having a child, that's a much more vivid foundation for a humanitarian case. For here, I'm a little bit reluctant to say it's a strong case. It really depends on things like, is it really viable? Can the evidence really be brought to bear with some research about cost of tuition, etc., and the skills of the parents to pretty clearly be unable to afford to have this child go to school? If that evidence is borne out, then the best interest of the child could be triggered, and then it could be said that, well, this child has a right to education in Canada, and there's presumably perhaps no other people who can be in Canada to take care of this Canadian child except the parents, and you don't want to separate a child from their parents anyways. That just violates all of the norms that we expect for a democratic country. So it's something to maybe consider at the end of the day. So with that in mind, I'll see if because we still have a couple of minutes for this. I'll just see if there's any other case. Oh, okay, there was a question, medical inadmissibility. So person indicated they have HIV. So the question is, will this be an issue for medical admissibility? So this is a very specific kind of medical admissibility relating to need for medication. Because typically there's a set of medication you need to keep the HIV in check. So the question is, how would this affect the admissibility to Canada? So in this situation, as you may know, there is the key for assessing medical admissibility is what is the cost threshold per year that would be projected if this person were admitted to Canada, including the cost of medication. So the number escapes me because it's revised every year, but I believe if the cost of the medication and or surgery exceeds something like 23,000. I mean, that's a very rough figure because I have not looked it up in a few months. If during the course of their application for permanent residency, there's a medical that's taken, and then if the Canadian panel physician says, oh, this person has HIV, and this will cost a certain amount of money in terms of medication, then this could mean that the person's might be inadmissible unless they could formulate a settlement plan to show that they have enough money to pay for the treatment, the perhaps medication in perpetuity as long as they live. From what I recall, because the medical inadmissibility financial cost threshold is 22 or 25,000. From what I recall, the amount of money these drugs cost is under that amount. So it's very unlikely that HIV would be the basis to refuse the permanent resident application on inadmissibility. So I don't think there's any other question to deal with there. So I'm just going to check if anybody online has posed a question. And I'm just waiting if there's anybody else who has a question to pose. I can wait in the meantime because I have a couple of minutes extra. And then we'll just see if there was somebody who emailed me a question last week for this. And, oh, okay, so there's a very, very peculiar specific question. The person was on a work permit but was abused by their employer. So they were able to get a vulnerable worker work permit, which is used because it's just harsh where you get abused by your employer and then you come all this way to Canada and then it seems very abrupt just to leave just because the terms and conditions of your work permit can't be fulfilled because your employer is abusive. So in those situations, there is the ability to get a work permit as a vulnerable person. But the question being asked is, can I extend this? So typically, if you're on a vulnerable person work permit, generally speaking, you cannot extend such a work permit. However, if the circumstances are compelling, then you could try to file a work permit extension along with a TRP, a temporary resident permit. A temporary resident permit is meant to correct a violation you've committed under the immigration laws of Canada and to still allow you to be in Canada despite the violation. So the violation could be something simple like not maintaining status or something serious like having a criminal record, depending on whether you meet the main recipe for success for a TRP, which is that the need for you to have the work permit is demonstrably high, and also the risk to the Canadian society and the integrity of the Canadian immigration system is low. So aside from that, there's no other way to really extend a vulnerable person work permit. So with that in mind, I think I'll just check once more if there's anything in the chat. Okay, I don't think there's any more questions to pose either from before this or after. So I hope you enjoy the rest of your evening, and keep in mind, if you have a question about immigration, you can reach out to us at www.chaudharylaw.com or the intake email clerk@chaudharylaw.com. And for that, I enjoy the rest of your evening. Bye-bye. Somebody who's applied for asylum inside of Canada and medical examination was received